So I'll be talking about the law and economics of environmental financial assurance and its wider application, including including a cross-sectional review of EFA and mining and pulp mills. So it's an empirical study that we're working on, started recently, examining the effect of laws on environmental liability. So stepping outside the corporation and corporate law rules now and looking at the wider legal environment, and the question really whether we can create an external legal environment which would solve the sustainability problem. So first of all, it's nice to think about what that problem is. So what is environmental financial assurance? The terms environmental financial assurance and surety and bond are used interchangeably in practice to mean a financial guarantee for foreseeable harm that a producer is obliged to complete. So they have to get a guarantor, a surety, a third party to guarantee some amount of money, which we'll talk about the value of, before they start mining, emitting emissions, deep sea mining, whatever it is. A legal requirement that a producer post a bond ex ante before they start, covering a certain period, which government will draw on to clean up if the producer fails to fulfill its environmental obligations. So the way I'll approach it is the first part's theory, the second part's empirical. You can't really do empirical analysis without a theoretical framework for thinking about the effects the law might have on society, its consequences for well-being and sustainability. On theory, it's be drawing on economics. I think I'm the only other economist in the room, according to Jennifer. So, I'll look at the economic analysis of environmental harm, the economic analysis of law on such environmental harm. So how does the law affect behavior? And then the economic analysis of the risk of corporate bankruptcy, I'll make particular reference to, given the interest in corporate law rules in this area. And then look at the way in which EFA fits into the broader kind of maybe optimal external legal framework that might help on sustainability. The empirical analysis, we've conducted a study of 18 countries in mining, contacting the regulators, reading their law books, with some high-level questions to answer, and then 3 in-depth to follow up. And then pulp mills, 11 country studies, 3 in-depth to follow up. So where do I start? Well, I start where economists start, with the problem of pollution, which is building an ANS's insight that the implication of the law of conservation of mass is the waste disposal problem. You can't dig material out of a mine or multiple mines and build a car and sell it without having the same amount of mass to dispose of as what you started with. So really, it's that physical law, the law of conservation of mass, that gives you the waste disposal problem and the pollution problem in all regards. So consumption is a misnomer. You know, if the idea of consumption is I consume something and it's gone, it doesn't go, nothing goes. And conservation of mass leads to waste. To address this, Mill in '72 and Solow, the Nobel Prize winner, separately advanced the idea of a materials use fee to be levied on specific environmental resources at a rate equal to the social cost, or what the word that's been used a lot in the sessions to the last 2 days, externalities costs, if the material eventually returned to the environment in the most harmful way. So Solow's point was, if you make the polluter or harmful activity pay the most that could possibly be costed or borne by people, then that would incentivize them to look at more efficient ways of doing what they're doing. Because if they can reduce that harm, then they will do it, obviously, if they've got the cost sitting at the end of the day facing them. So the fee was initially seen to be equivalent to the refundable deposit, long used to encourage recycling. So you post a bond, you go and pollute, and you don't do as much damage as they thought you would, and you come back and you get your bond back, or you clean up the mess. So the fee is now commonly referred to as an environmental bond, or an environmental financial assurance. So what's happened? Did this idea get picked up? Well, I mean, the good news here, and I think I'm actually quite positive that we will solve the sustainability problem, is that it did get picked up very quickly. So in the 1970s, USA coal production transitioned from deep mining, underground mining, into surface mining, and that caused much more environmental pollution problems. There's much more waste left lying on the road. lying on the land and falling into the rivers. So prior to 1977, there was no federal law authorizing reclamation requirements to restore lands and waters affected by mining practices. And what's interesting is that we're talking about coal miners who are also responsible for 43% of carbon emissions. So we're talking about a really interesting industry and focusing on that. From 1977, the US federal law, authorized a federal regulatory program requiring financial assurance or bonds for coal mines operations on federal land, non-federal land, and on tribal lands, i.e. all lands. The non-federal lands was done by cooperative federalism, which I won't go into here, but so it's comprehensive. 50 years after the idea was invented by a Nobel Prize winner, 40 years after the first law was introduced, we end up with $10 billion in environmental bonds paid by coal miners. Most of it, 76%, is in the form of a surety, which is a third-party promise or guarantee to pay. 12 and 11% collateral bond and self-bond. Collateral bonds are just cash, certificates, whatever, basically collateral. And self-bonds for the large, financially, robust firms, they do self-bonds, and you have to go through procedures and criteria to meet that. So in 40 years, there is quite a lot of money that's been collected already. So far then, we've seen the history of an idea, the EFA, how it was adopted pretty quickly and how it spread, and we've actually got this money now to clean up things. The questions then are theoretical. What are the predicted effects of the EFA, and can we go and work out what it's done? Does the EFA have a wider application, e.g. to CO2 emissions, to deep sea mining? As Nauru is about to start deep sea mining, well, what's the difference from coal mining? Maybe they should have to clean it up. How do we approach that? Empirical, how far has it spread? Once we get to the empirical word, we've got these predictions and hypotheses. How far has this gone beyond the states? We've got those states that are, got this law. There's no variation in the states anymore. It makes it hard to test the effect of the law. So we need to look at other jurisdictions and change within the United States over time to get change in the law in order to evaluate the effect of the change in the law on the dependent variable of interest, namely the waste and how it's paid for. So in mining, we look at other jurisdictions. In pulp and paper mills, we looked at other jurisdictions. We got into pulp and paper because we were interested in forests as a carbon sequestration thing and interested in what was going on there and what have been its effects. So the general stock flow model, the theory then is that you start with gas, liquid, and solid, the various states of matter. They end up being in the atmosphere, the oceans, and the land of the earth. And then you get ecosystem services that are released naturally. No one has to do anything. They just turn up, plant fruit off the leaves, which are delivered and create value to people using them. So Robinson Crusoe on an island, picking leaves, catching fish, lying on the ground in the sand. It's all just there for free. What then happens is with specialization and division of labor, Adam Smith's insight, you get team production, you get something called a natural resource. They usually only talk about land in the classical economics, but natural resource is combined with labor, human beings, and with capital to start some production. And let's produce these apples in orchards, sell the products to consumers, and you get consumer and producer surplus. That's then value that you add to the value from the economics, from the ecosystem services. So the consumer surplus is the value that they get above the price they paid for the apple. The producer surplus is the value they got above the cost of producing the apple. So remember that that is very important. There's been a lot of knocking on the head of the for-profit corporation, but actually it has a huge social welfare function and benefit, which is that it ensures that production costs are actually minimized. An owner who's worried about profit is forcing costs down as much as they can without compromising the sale of goods and trying to get as much a high price as they can from the consumer to fund further investment in whatever. Now, competition will limit that, but so the for-profit motive provides a very important, social function in terms of generating value. So let's not knock it. So value, we have consumer and producer surplus adding value. The problem is the first law of conservation. You've got harm, a flow of waste with a pollutant increasingly. You've got consumers ending up with a car. What do I do with it? Most countries are importing a huge amount of waste mass that they originally didn't own. Now, what are they going to do with the cars, right? So this mass doesn't go away. So it becomes a stock of waste. So there's a flow of waste and then there's a stock of waste. And some of it is very polluting, like with mining, various acids, sulfides, and whatever. So in mining, you get toxic solids, toxic liquids, creating harm. And the question is, does the harm exceed the value created by the product? If so, then the harm should go ahead. But people should be compensated for their harm, right? That would be the answer, because it's going to add more well-being. It's not going to hurt the well-being of anyone if persons are made whole through compensation. So, but it's hard to detect. So Kosa's insight was really society as a system of exchange. Forget terms like markets and contracts, that social exchange or whatever, people are exchanging things. But the problem is, if you're being harmed by someone, you can't identify them. It's very hard to tell them that I have greater value if you don't harm me this much, and stop doing it. So exchange won't work, right, all the time. So then that's where you explain the law of liability. And in all of these industries that we've looked at, they've all got liability rules. They've got the common law or their own previous law, and they've got huge statutory frameworks all over the place saying these companies are liable. The problem then is solved then if the courts were cheap and easy to use and costless, like markets. So they'd be compensated, which would create an incentive to recycle. You wouldn't, throw your lithium battery away. You get it recycled into a new lithium battery. You get the abatement incentive, and you get the mitigation offsets. So you'd buy forests if you were polluting CO2. You'd abate your coal mine trailings. So all the incentives are there if the price is right, if the liability is right, if it factors in all the social costs of the harm. So the problem then is bankruptcy, right? So the company might go bankrupt. Now you can have bankruptcy arising from variation in prices and variation in costs, the ordinary incidences of market. Companies fail, some succeed. But you can also have these problematic individuals who go bankrupt for what they do with a strict liability rule is they keep the mine open to the point where actually they go bankrupt, and then they avoid liability, and we get more harm as a result because they lengthen the duration of it. So the answer then is the bond. The bond then you could use for GHGs, for greenhouse gases, and then you've got a right, which is to pollute, subject to liability, and posting a bond, which is tradable. So that is basically a solution. So we're looking at what happens with mines. We looked at these in Canada, USA, South America, Australia. We looked at Canada, USA, Europe, and Asia for pulp. High-level questions was, do they have a well-developed assurance framework? Are there government backup funds in case things go wrong? We found none of the 11 jurisdictions have a well-developed financial assurance requirement in pulp mills. So financial, but 100% of financial assurance in mining. So you've got variation. In mining, all of those jurisdictions we surveyed had very advanced environment liability rules and bonds posted to cover it. But in pulp and paper, we had none. So the good news, the conclusion is, environmental protection in EFA law seems ripe for wider application than just coal mining. There's a data-rich cross-sectional time series now of a number of different countries that have introduced the bonding system and laws over time. Variation in law over time and across country means that we can pull the data and, using the changes in the legal environment in different locations, test the effect on the dependent variable of interest like waste. So I think it's easy to talk about sustainability theoretically. What I'm interested in is having a good theory, and then testing the hypotheses. And then that means collecting data, which, believe me, this is taking a long time. I think we're 18 months into collecting data at the moment. It's very costly. Yeah. So thank you.